All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good morning. We have one case on the calendar this morning, Marcus Ford versus United States. Counsel, you may proceed, Mr. Lipper.
Thank you, Judge Glickman, and may it please the court. Greg Lipper on behalf of the appellant, Marcus Ford. I'd like to reserve 4 minutes for rebuttal. Thank you. So the trial court's supplemental findings at most established that the officer was able to determine, after feeling the outside of Mr. Ford's pocket, that there was a vial in his pocket that was, quote, consistent with PCP use. Of course, a vial would have also been consistent with any number of other things, such as a person with diabetes with insulin, or someone who was who had children's ibuprofen, or someone who was selling essential oils, as people were known to do around the district in the recent years. And so that alone, even under Ball and the court's most expansive cases, would not itself establish probable cause. And the additional factors on which the trial court relied do not bridge that gap. Perhaps most importantly, the trial court impermissibly held Mr. Ford's revocation of consent, the basis for the previous vacatur, against him, holding that it was evidence of wrongdoing, overlooking the clear reason why an innocent person would revoke consent before an officer reached into his pockets, and in any event, failing to credit him, or credit as evidence of innocence the fact that he had originally consented in the first place.
Can you? I'm sorry to interrupt, Mr. Lipper, but what is the state of the law on that question? Whether a judge can consider sort of the gestures or the behavior of that is inherent in the revocation of consent to support probable cause?
Well, I guess I would say two things to that. The first thing is that there's the general line of cases, from the Supreme Court and from this court, making it clear that in most circumstances, you can't read too much into a citizen's sort of declining to talk to law enforcement or declining to keep talking to law enforcement, because they, of course, have the constitutional right to not talk to law enforcement or to stop talking to law enforcement. So I think that's the first thing. But I think in the context of consent, and not just generally, but the particular revocation in this case, I think relying on it would be especially troubling. So first of all, the doctrine says that, as we talked about when we were here last time, the revocation of consent has to be clear and unambiguous. And in the context that Mr. Ford was in, the only way, given the timing, the only way to unambiguously revoke consent, as would satisfy the doctrinal requirement for a clear revocation, would be to make the gesture that he made. If he had simply said, "Stop searching me," or "Could you please stop searching me?" it would have been too late. So I think that's the first point, which is, if the law is going to require an unambiguous...
Wait a minute. You think he couldn't get the word "stop" out any quicker than he could grab the hand?
I think by the time he said "stop" or "please stop" or something like that, and the time it would take to process that and actually stop, I don't know for certain exactly how it would have played out, but I would say given that we're talking about a matter of seconds, I would say the fastest way would certainly be to, put his hand and to make it clear, physically, that he didn't, want the hand going in his pocket. But and I think that's the second reason why I think it would be especially problematic to rely on revocation in this case as evidence of wrongdoing, which is that I think any person would distinguish between someone patting down the outside of their pants and reaching into their pocket. I mean, I can even just think about the security that I have gone through, be it at airports or at the courthouse, I am very used to marshals or security people patting me down, especially if I set off a metal detector, patting me down to make sure there's nothing in my pockets. I cannot think of a situation though where a marshal has reached into my pocket, and if they had tried to do that, especially without much warning, I think I myself would have certainly reacted to that, but at a minimum would have understood that to be a sort of different level of intrusion, and one that I might not be comfortable with, even if I was comfortable with an initial pat down. In any event,
then, assuming we agree with you that it was improper to take that act of revocation into account, don't we have probable cause without it?
I don't think so. And so obviously the fact that, and the fact that a vial alone could be used to store PCP does not itself establish probable cause, because even the decision in Ball, which is the sort of I think the paradigmatic plain field case, even that case made it clear that the feel alone did not suffice, that they had to rely on other factors. And
let me remind you that we've said, and the Supreme Court has said, probable cause is not as much as a preponderance of the evidence. So it doesn't have to be certain, does it?
It doesn't have to. I'm sorry. It doesn't have to be certain, but it has to be more than a hunch. And if you look at the language of Ball, so Ball said, and this is on page 980, an officer's tactile identification of a pill bottle standing alone does not give rise to probable cause to seize the bottle or open it to reveal its contents. And I think we're in a similar situation here, because a pill bottle could be used to store illicit substances, or it could be used to store prescription pills, in the same way that a vial could be used to store an illegal substance, or it could be used to store insulin or perfume, or any number of uses for a vial. And so then I think you have to look at what else was at issue, or what else was available that might contribute to a finding of probable cause. We've already talked about why the revocation of consent should not factor into it. And if you look at the other factors that were present in Ball or some of the other cases, you can see that they far exceed what was present here. So
isn't Ball, I think, if I'm remembering Ball right, that's the one where the court went out of its way to say that we probably wouldn't be reaching this result if the defendant didn't keep touching his pocket, even when officers were saying not to do that. It sort of sounds like what happened in this case. Not, it's more marked, but then again, that gets you back into the revocation of consent.
Right. Well, so I think the first part of your question, I think you're correct that Ball said the most important factor was that Mr. Ball kept trying to reach into his front pocket despite being told not to, and even after being ordered outside of the car. In other words, there had already been a seizure, an involuntary seizure that had taken place in Ball, at which point he could have, he would have been expected to comply with the officer's instructions. Whereas while the officer pointed to, Ford being startled and similar things before the search took place, at that point, Mr. Ford then consented to a search. And other than the revocation of consent, which was entirely, within his rights at that point, he, didn't do anything else. He wasn't disobeying any instructions from the police officer. So I think there you have a level of, in Ball, you had sort of active obstruction, even after an initial seizure had taken place, and despite repeatedly being told not to. Whereas in this case, you didn't. And you can look to some of the other cases that Ball relied on, and you can see the types of examples of factors that distinguish it from this case. So, for instance, Ball relied on a case out of Michigan called People versus Champion, which Ball not only cited but discussed. In that case, the officer was aware of the individual's history, that the individual had previously had a drug conviction and a weapons conviction. He refused to remove his hands from his sweatpants, even after being asked to do so by the officer. And the pill bottle, or what felt like a pill bottle, was stored in the defendant's groin, which is far less consistent with an innocent explanation. Even then, even with all of that, even with the prior history, the drug convictions, the gun convictions, and the fact that the pill bottle was stored in the groin, even then, Champion said, and Ball quoted this language in its decision, if the pill bottle in Mr. Champion's possession had been found in his jacket pocket, or if Mr. Champion had not had his hands inside his sweatpants and he had no pockets in which to carry a pill bottle, the result may have been different. So even with obstruction and a specific history, if the bottle had just been in his pocket, or even if there had just been a reason for it not to be in his pocket, it likely would not have established probable cause. And so here, you don't have that kind of active obstruction, even during the voluntary search, other than the revocation of consent. And the vial is being stored exactly where it would be stored if it were being used for innocent purposes, which is in his pocket. And so I think, and there's a number of other cases, cited in Ball, and I think each of them again had unique factors. So, for instance, you had in another case that Ball cited and relied on, State versus Trailer, out of Louisiana, in which the vial was found in the defendant's sock, right? So again, this is not where you would keep it if it was just insulin or something like that. And you had the defendant who continued to reach for his leg even after being even after being told not to. So again, you have active disobedience and a unusual or counterintuitive place to be storing the item. Or in other cases that the court has decided in which you had an actual smell. So, in a case like Minnick, which I believe we discussed in our original set of briefs, or at least quoted in our original set of briefs, where you had the detective, detected the quote, strong smell of PCP, right? Whereas here, there was no smell. And I should add, and I think this is sort of contributes to what's, the reasonableness, the objective reasonableness of the officer's conclusion, that the feel that was taking place, the pat down, so the vial that the officer said he felt through a layer of clothing, so through the defendant's, through Mr. Ford's pants, and then the vial was contained in a rubber glove, which also had in it a large plastic bag, which had in it 13 smaller plastic bags. And so you have a vial with a bunch of rubber and plastic around it through the leg of Mr. Ford's pants. And so the level of precision, objectively, that anyone's going to get through that feel is itself compromised. And so that's another reason that causes this case to fall short of some of this court's cases and the cases that this court has relied on, because you already had objectively, however strong of a hunch the officer had. And I understand the officer from even before the pat down was convinced that Mr. Ford had PCP on him, but ultimately however subjectively confident he was, the touchstone is objective reasonableness. And when you have a feel that was, I would say, less than plain at best, with a number of innocent uses for a vial, and the other factors which do not rise to the level that you found in other cases, with no disobedience of instructions, no knowledge or testimony about the officer's awareness of the particular Mr. Ford's particular history. No, there had been testimony about having seen vials in that apartment previously, but certainly nothing was seen that day. And so no reason to believe there's active drug exchanges or uses happening, on that day, even assuming that it's reasonable to say that, that the people who sold to people in this apartment made house calls. And so I think you're at the end of the day, the feel here is doing too much work, and the feel itself through a number of layers of fabric, rubber, and plastic, at best gets you a apparatus that can and is often used to hold non-contraband. At the time, I mentioned the sort of essential oil salesman at the beginning of my remarks, but I think that's just an illustrative example. These were, I think it's not been as active because of the pandemic, but I've even written up in the newspaper, people would outside of metro stations or other kind of major areas, they would, have in their coats, and they would sort of kind of plop down on the sidewalk and sell essential oils in little vials. And I have not seen this myself, but I am reliably informed by a colleague that, in fact, this used to take place right outside the Public Defender Services office, which is right across the street from the courthouse. So this is the sort of thing. It's an innocent act. Using plastic vials with liquid in them could have been taking place across the street from the courthouse while Mr. Ford's suppression hearing was going on. And so, and that's just one of many other example. And so,
Can I? Oh, no,
go ahead, Judge
Judge.
Glickman. You go.
Well, I'd like to get back to the question of the evidentiary significance, if any, of the revocation of consent. Are you aware of any case law that has actually squarely addressed this kind of issue?
I am not aware of a case specifically addressing the issue in the context of consent. But I know this court, both, I think, in earlier cases and more recently, has addressed it repeatedly. And most of the cases in which the court has addressed it, and most of the cases in which the court has said it was not proper to rely on sort of, a person sort of cutting off contact or declining to speak to officers, has taken place even in the context of a Terry stop and reasonable articulable suspicion, which requires a lower threshold than probable cause and is taking place out in public on the street, in which your reasonable expectation of privacy is lower, whereas this is taking place inside an apartment building, inside a residential building. And so if the court is hesitant, as I think it has been, to rely on declining to cooperate, even in the context of a Terry stop, and even when that prospective Terry stop is taking place out in public, I think it needs to be even more cautious when you're talking about a residential building and when you're talking about probable cause. And I do want to go back to
the thought that occurs to me is that one could make the following argument: declining to permit or to agree to a frisk, a pat down, a search is one thing. A citizen can do that, and it does not by itself connote any sort of wrongdoing, or at least any the linkage between refusing to consent is not very, and wrongdoing is very weak. And of course, as you say, there's a constitutional right. Once you've consented, though, and the officer does some patting down and then starts to get warm, as it were, get close to the area of concern, and the person suddenly withdraws the consent, a natural inference is that, barring some other explanation, is that the reason for the revocation is that the person has something to hide and is afraid now it's going to be found. And I'm wondering whether just because there is a constitutional right to refuse to consent and to revoke consent, that it automatically follows that the logical inference that an officer might draw from that conduct can't be taken into account in deciding whether there is either reasonable articulable suspicion or probable cause. I don't want to take up your time with my meandering on this, but I'll just point out that there are some types of withdrawals or revocations of consent that I suspect we'd all say could be taken into account. If, in this case, Mr. Ford had manifested his revocation of consent by running away when the officer got too close to his pocket, I suspect we would treat that as having evidentiary significance. So I wonder, whether it's so clear that it's improper to include in the calculus the fact that Mr. Ford instinctively or otherwise reached with his hand to try to shield what was in his pocket from exposure.
I would love to address this. I see my time has expired. May I
Yes,
answer?
you may. Yeah. Yes, you may.
You. So I think there is both I think there's both a practical explanation for why it does not in fact produce that inference in this case, and then I think there's also an important structural reason kind of implicit in the consent regime that it would not be a good idea to draw those inferences. So the practical reason is, I think, consent. I think I think there are just going to be different things that even taking the police officer out of it, there are going to be different things that someone is comfortable agreeing to. A pat down is intrusive, but something that most of us are used to because we deal with it, in situations if we enter particular buildings or get on planes or, and especially if we set off a metal detector or otherwise, or, we're going to a baseball stadium even and they see or something goes off, we'll get patted down. And I think that doesn't strike any of us at this point anyway, as unusual or especially intrusive. I think someone reaching into your pocket, your front
May I
pocket.
stop you there for a second? Was the officer reaching into his pocket or was he patting the outside of it?
Well, he had been patting the outs. So he initially had been patting the outside of the pocket. So when he felt what the officer said he thought felt like a vial, was done outside, and then he was actually going into the pocket to retrieve the item, and that's when Mr. Ford revoked consent. And so I think that's actually entirely normal for the most innocent of people, because for a person, let alone a government official, be reaching into your front pants pocket is it's a whole level of intrusion and intimacy that I can see not wanting someone to a line that you wouldn't want someone to cross. And the fact.
Can I ask you another question about that?
Yes.
What, I just don't remember. How was consent given? What was it along the lines of, "Sir, may I pat you down?" And what was the actual consent?
I will have to go back and I will hopefully be able to get the precise exchange, or at least from the transcript on rebuttal. I don't recall off the top of my head whether it was pat down. My recollection is it was more of a "can I search you?" I don't recall if it was a "may I pat you down?"
Yeah, that's what I had sort of thought, but I realized as you were discussing this, I wasn't sure. Does that make a difference?
I don't think so. Again, because
the deal at the outset was a search.
Well, right, but I think even when you're, so just as an example, I mean, even if an officer goes up to someone and they say, "May I search you?" and you say yes, I think presumably a person isn't assuming that they've consented to, say, a body cavity search or a strip search, even though they have provided.
I'll agree with that.
A sort of a blanket consent. So I think every person is going to have a level of sort of intrusion or intimacy at which point they get uncomfortable. The fact that, and I think it is entirely understandable why a officer or anyone reaching into your front pocket would sort of trigger a level of privacy concern that was not present by the pat down. but the question you asked, I think, also just goes into the sort of the broader sort of constitutional reason that if the consent doctrine, and you can see this, even in Florida v. Bostic, the Supreme Court decision about consent on a bus, in which the court is sort of more generally embracing consent as a sort of, if freely given, consent is desirable, I think is a sort of a undercurrent of the Supreme Court's decision in that case and a number of other cases. But if consent is desirable, if consent is something that is to be encouraged or at least not actively discouraged, if it's a useful tool for law enforcement, and if it's a way to keep the adversarial process under control for as long as possible, then we don't want to say to citizens, once you consent, you're in for good. Because at that, that we would not want to treat the revocation of consent as more suspicious than the original decision to decline consent. Because if you can't, if you are going to be raising suspicions, and if the law will treat you and use against you a decision to terminate consent, you, I think, and an innocent person in particular, and especially, would be far less likely to agree to provide consent in the first place. And in that regard, it will ultimately make it harder to get people to consent. There's already a bit of a thumb on the scale because you have to revoke your consent unambiguously. So there is a bit of inertia built into the process. But certainly if I were advising a client, I would certainly say to a client, look, if you need to think twice or three times about ever consenting, because if you have second thoughts halfway through, they're going to use that against you. And I don't think that's, I don't think that's certainly not good for the privacy of citizens, but ultimately I don't think it's good for law enforcement either. With that, I will reserve the remainder of my time.
Thank you. Mr. Lenerz.
Thank you, Your Honor. Good morning, and may it please the court. Dan Lenerz for the United States. I'm happy to dive into this revocation of consent issue, but I think it's really a red herring here, and the court need not decide it, because as the trial court actually found, there was probable cause for Officer Branson to seize the PCP vial from the defendant's pocket even before the defendant grabbed his pocket and revoked his consent, based upon Officer Branson's plain touch of what he immediately recognized to be a vial consistent with PCP distribution.
Mr. Lenerz, what is the significance of it? Mr. Lipper started off by talking about the vial consistent with PCP. Is there any significance to that? And can you tell me what is the state of the law? Like the plain feel sort of have this sense of it, like if you feel something that is truly identifiable, like a gun, that is a gun. That seems like the paradigmatic idea of plain feel. But here we have something that can have innocent purposes. Where is the law on this? What is sort of the best case that gets you into this area, and does consistent matter?
I think the best case that gets us into this area is this court's decision in Ball. There's an extensive discussion of the plain field doctrine in Ball. And I think that consistent with matters in the sense that, as Ball made clear, all the officer needs to have is probable cause that it is contraband. So the officer need not have certainty. The officer need not even think more likely than not that the object he has touched is contraband. Instead, what Ball makes clear is based upon the officer's plain feel and all of the attendant circumstances. The question is whether the officer had probable cause. And
Ball does seem to go out of its way to gives the impression that it views as a very close case, basically saying that the feel of the medicine bottle, I think it was a pill bottle, wasn't the biggest thing. And it probably wouldn't have been probable cause, without this unusual fact pattern of the defendant continuing to touch his pocket, I think it was, when the officers were telling him not to.
I agree, Your Honor, that Ball turned on the fact that in addition to feeling a pill bottle, the officer also knew that drugs were being stored in pill bottles at that time in the district, and the defendant's repeated attempts to put his hand into that pocket. But here you have even more than you had in Ball. First of all, a pill bottle is a much more common object for someone to carry around than a vial. Regardless of Mr. Lipper's claims about people selling essential oils on the street, I think we all know from common experience that it is unusual to carry around a 1 ounce glass vial. Second, unlike in Ball, here there was evidence of ongoing dealing of this exact type of drug in this exact type of container in this exact apartment building at this exact time. The officer testified that he and his partners had been walking through this complex, and in the recent days preceding this arrest had seen glass vials consistent with PCP with tobacco in them discarded in the hallways and the stairwells. In addition, the officer saw the outline of the vial in the defendant's pocket, which also wasn't present in Ball. And then, similar to the defendant's evasive actions in Ball, here the officer described the defendant's extremely unusual, I think he called it unnatural and weird response to seeing the officers. So if you'll recall, the defendant was walking down the hallway toward a door. The officer said he was a foot or two away from the door into the stairwell, and based upon common sense, the officer knew the defendant was going to enter the stairwell. Upon seeing the officer's exit, the defendant displayed a deer in the headlights look, was frozen stiff, and then as the officer was talking to him, the defendant started turning the exact opposite way to shield the right side of his body from the officer. As the officer continued to talk, the defendant continued to turn until he was facing 180 degrees from the stairwell where he was going, and then he put his right side up against the wall, almost like hugging the wall. So the defendant was clearly being extremely, as the officer said, unnatural and weird or evasive or nervous, trying to shield this right pocket where the PCP was hidden, just like in Ball, where the defendant kept going to his pocket where he had hidden the pill bottle. So here, in addition to the nervous and evasive behavior, the fact that the officer immediately upon touching this vial recognized it to be a hard glass vial consistent with PCP use, there was evidence of recent PCP dealing in this specific building, all of which was ample or plenty to establish probable cause, regardless of the revocation of consent. And that's what the trial court found. The trial court, in her order, actually found, based on the facts I've just described, that the officer had probable cause to seize the vial from the defendant's pocket. And then she went on to say when the defendant grabbed his pocket, that was both revoking his consent, but simultaneously confirming the officer's well-founded observations and conclusion that the
That comes back to, I guess, where you started, where you were saying we didn't need to decide the extent to which that finding by the court supported probable cause, but do we care that that seemed to be something the judge herself cared about?
Again, the court seems to be wrestling with this issue, and as a doctrine of constitutional avoidance, you don't decide issues you don't need to decide. Here, you don't need to decide it because there was probable cause without it. And again, the judge found probable cause without it and then relied on it as confirming the officer's suspicions. To answer some of the court's questions of defense counsel, the officer testified that as his hand was on the vial, the defendant grabbed his pocket to stop him from going into the pocket. So the officer wasn't putting his hand into the pocket at the time. The officer was manipulating the vial when the defendant grabbed his pocket. And that's on page 10 of the October 26th transcript. In terms of the state of the law on this issue, to Judge Glickman's question, the officer said to the defendant, "Can I search you or can I check you?" The officer didn't remember which one he asked. Finally, in terms of the state of the law on this issue, like the court, I haven't seen a case specifically dealing with revocation of consent. However, we cited in our supplemental brief the court's decision in Brown, which says that where a suspect reacts in an unusual way to police investigation short of detention, this may properly be included in the calculus. And the court has since relied on Brown in cases like Holston to say that officers may rely on otherwise innocuous or constitutional conduct in informing their reasonable articulable suspicion or probable cause analysis.
What do you make of Hawkins as to where that falls on the line? There seemed to be, quite a bit of unusual, weird behavior in that case, and yet it did not, the facts did not support probable cause, if I'm remembering right.
Your Honor, I'm sorry, I don't know which case Hawkins is.
Okay, that's the one that with the satchel, it has some things in common because the officers were saying that I think one of you cited it. It's like a high crime area, and the officer testified that there were lots of cases of guns being found in satchels, and the man had the satchel and he was, doing weird things, evasive actions. And the court found, I think it was a probable cause case, no probable cause. One thing was there was no telltale bulge, where I guess that would be a distinguishing thing. And it's also, the idea of guns and not drugs. But anyway, you don't have to respond to a case you're not familiar with.
Yeah, I'm sorry, I'm not familiar with it, Your Honor. I think the answer is that in all of these cases, as I understand the law, the court evaluates sort of on a gradation how unnatural the defendant's reaction is, or officers are allowed to include in the calculus how unnatural the defendant's reaction is. And
Mr. Lenerz, let me ask you a question about the doctrinal underpinning of our analysis. 2 or 3 times this morning, you've used the phrases probable cause to seize. The government's brief sometimes says probable cause to search. But as I understand it, the analysis is really a little more protracted than that. It would have to be probable cause to arrest. And then a search incident to arrest that's properly conducted before the arrest occurs. Do you agree with my understanding of the doctrine?
not entirely, Your Honor. So I would agree that search is distinct from seizure or arrest. That probable cause to search is not enough to allow an officer to touch a defendant or reach into his pocket. Here, that issue is answered by consent. The defendant consented to the search and the officer conducted the search. So the question is whether, based upon what the officer felt during the search and the attendant circumstances, the officer had probable cause to seize the item.
But why? How could he do that without a warrant? Usually we have to have exigent circumstances or some other exception to the warrant requirement.
That's what Minnesota versus Dickerson and Ball allow. They allow that once the officer feels an item and he's lawfully feeling the item, whether it's a Terry frisk or in this case consent, if the officer has probable cause to believe that it's contraband, the officer may seize it. And the court likened that to plain sight cases in which nothing about the Fourth Amendment's protection is advanced by requiring officers to go get a warrant for something that they plainly see to be contraband. And that's what Minnesota versus Dickerson said is under the same conceptual, the same thinking says that the officers need not go get a warrant for something they plainly feel to be contraband.
Got it. Thank you.
But I actually think there's no difference between probable cause to seize and probable cause to arrest in that circumstance. I think it's ultimately the same question, which is there probable cause to believe the defendant is in possession of contraband? If so, the officer may seize it and check it, as in Dickerson or as in Ball, or the officer can arrest the defendant and then search incident to arrest, seize the item and check it. In this court's recent decision in Ellison, 238 A 3rd 944 talks about this in footnote 3. Not this exact distinction, but the same idea of these probable cause collapses in this circumstance to the same question. But ultimately, here there was ample probable cause based upon the plain touch and the attendant circumstances, as the trial court correctly found. And for that reason, we believe the trial court's ruling should be affirmed.
One question for you before you sit down, and I meant to ask this of Mr. Lipper, and it slipped my mind. An issue has been raised on appeal about the fact that the judge decided this issue on remand without calling the parties in for a hearing or reopening the record in any way. Did either party make a request for a hearing or for any sort of reopening of the record when we remanded this case?
No, Your Honor. And in fact, defense had ample time to do so. This court's remand order occurred in late February, and the trial court issued its decision in early June. So there were more than 3 months, about 3.5 months, in which the defense could have filed something in the trial court, either a supplemental brief or a request to have a hearing, and the defense made no such request.
Would that have been proper? I wasn't sure whether you were arguing in your supplemental brief that it shouldn't have been allowed anyway.
I'm not sure. This court's case law says in a record remand, the trial court may do nothing other than what this court ordered. I think that when this court orders the trial court to make further findings, it probably would not be improper for the trial court to ask for a supplemental briefing and hold a hearing. That would seem to be an overly strict reading of the record remand rule. The trial court could not, for example, have taken on additional evidence. That would have been, I think, beyond the scope of the court's remand. So, we agree that it's a discretionary ruling, but here there was no such request, and it's hard to see how the trial court could have abused its discretion in not receiving additional briefing or holding a hearing when the defense never requested it. Thank you, Your Honor.
Thank you. Mr. Lipper, are you reserved a few minutes for rebuttal?
Yes. So a couple of points. The first is Mr. Lenerz's point that the revocation of consent came at the point that the officer was manipulating the object inside of Mr. Ford's pocket. I actually think kind of almost provides an even greater justification for the revocation, because now you have not only a person putting his hand inside your front pocket, but moving his hand around inside of your front pocket. And so I think, far from undermining
excuse me, I don't think Mr. Lenerz said that, and I don't think the court's findings say that. The impression I get is that he's still got his hand outside the pocket, feeling the vial when your client grabs the officer's hand.
That was my understanding as well. I just did want to address, because I think Mr. Lenerz was suggesting that the revocation came later on in the process. And what I want to make the point is that whether it was on the way in or inside and manipulating, in either situation, there would be a serious privacy reason why someone would revoke consent in that situation for entirely innocent reasons. And so I think the circumstances of the revocation here do not contribute to a finding of probable cause. And again, they contrast notably with Ball, in which the defendant was actively disobeying. The defendant had already been seized and was actively and repeatedly disobeying instructions. So I think that's the first point. The second point is I want to address a couple of the other circumstances Mr. Lenerz addressed. So the kind of history, I think Mr. Lenerz overstated what the history was. Mr. Lenerz said there was, sort of clear evidence of PCP dealing in that building, and I don't think we know that. There were vials lying around. Even those vials, just to be clear, were consistent with PCP. There was no PCP in them when they were seen. But even putting that aside,
what would be the importance of the tobacco inside the vials?
I think honestly, I don't use enough substances or any substances to really answer that question. But I guess the only point I'm making is that the officer has not said that he saw PCP.
But the officer knew what a dipper was. So the tobacco remnants would have meant something to him.
Well, but I think this is my ultimate point is that we know, if we assume that that those vials had previously had PCP in them, all that tells us is that PCP was being used in that building. And one or more people in that building was addicted to PCP. That does not tell us how they're getting it or where they're getting it, whether they're getting it on the street or in a different neighborhood. So I think the inference to, I saw a vial here the other day and, oh, the dealer must be coming into this building, making house calls to customers, I think is a leap. And there's nothing specifically in the record about actual dealing inside or even around that building, and no other reason to believe it. And so I think that's what's missing in that sense. I think, Hawkins, which is a case we did cite in our briefing, in Hawkins, I think you had more specific evidence of a recent crime, a recent violent crime in that neighborhood. And even there, when we're talking about a Terry stop and reasonable suspicion, that did not provide a meaningful contribution to reasonable suspicion. And here, it's even more remote. There was nothing that day, and the evidence that was there showed only use, not distribution. And we talked about this some at the last argument, and I don't want to belabor the point.
Well, let me stop you for a second, if I may. I'm not sure where that gets you. Ford could have been a user and not a distributor.
He could have been, but there, I think, again, does now we're at the point where sort of, and I think this is kind of what I was getting at that we talked about last time. If you happen to live in an apartment building where one or more of your neighbors has a substance abuse problem, which is, I think, probably not an uncommon situation in many, or certainly in many buildings or many neighborhoods, then if not most, then your privacy rights are diminished. And I think that is
let's go through this step by step, though, because Mr. Lenerz, I apologize, Mr. Lenerz, hope I've got that right, was pointing out the behavior of Mr. Ford as one of the key factors. So you have, as it were, three legs to the stool. You have the environment, which appears to be an environment in which drug use, and in particular, I suppose you could say PCP use, is rampant. You have Mr. Ford's behavior, which was variously described as weird and strange and indicative of something incriminating when he confronted the police. And then you have him consenting to the whether it was consenting to a search or consenting to a checkout. He probably knew what that meant. You have the officer's perceptions on under the plain field doctrine, which, to be sure, do not prove beyond a reasonable doubt that the item found, that the item that the officer perceived to be in Mr. Ford's pocket was contraband. But taken all together, why is that all those things don't give rise to a reasonable suspicion on behalf of a prudent officer that this is contraband, probable cause?
So I'll try to answer that holistically and then address the individual components. So holistically, I still think, for reasons we discussed, that the overall circumstances fall short of what was present in cases like Ball, or in some of the examples that Ball relied on. And Ball, as Judge Beckwith pointed out, really did sort of, was itself sort of, I think, on the outer limits of what was permissible, both in considering evidence beyond what was felt and also in sort of allowing that evidence to justify what was ultimately not sufficient based on feel. And so you did not have active disobedience. You did not have a sort of a number of other factors, that you did in Ball. And so the overall totality of the circumstances, I think, fall short of Ball and the cases cited by Ball. I think that's the first point. On the individual points, I don't think any of these really contribute enough to get to that holistic point. We've kind of, I think, talked about the revocation of consent in detail. The only point I'd add is, and again, this is another distinguishing factor from Ball, if you're going to hold the revocation of consent against Mr. Ford, then I think you have to also credit him for being willing to consent in the first place. He could have run away. He could have, left the building. He did not do so. He said, yes, I consent. And if revocation is evidence of guilt, then the decision initially to consent has to be evidence of innocence.
Is that true in every case? Like, this is your one way, or it can't be a one-way ratchet argument, right? It's what about, would that just have to be relevant every time it happens? Or would this be an example of a case where, since he later revokes, maybe the consent wasn't as relevant as it might be in another case?
I think certainly if the revocation, if the manner of revocation was the person punched the officer in the face or karate chopped him to the neck, I think the fact that he had the right to revoke doesn't mean that you couldn't draw any inferences from the manner in which the revocation, especially if there was no apparent reason for it. But here, I think he consented to the search initially and then revoked only when the level of intrusiveness changed materially. And so I would say at worst, it is no significance either way. But if anything, I would actually say the initial decision to consent is perhaps evidence of innocence, and the revocation is understandable given the escalation. But the other circumstances, what the officer described as the deer in headlights look, I have to say, I think obviously I can see that the officer acknowledged it was what he described as an unusual reaction. At the same time, it almost seems, it seems almost reasonable to have an unusual reaction when you're kind of going about your business, about to go into the stairwell of your apartment building, and several police officers unexpectedly come out the door.
Well, if it was just a reaction of surprise, even during the headlights, that I would tend to minimize that, I suppose. But here we have a description of Mr. Ford's behavior as if he were shielding something on the right side. I forget which side of his body it was, but on one side of his body. It's more evocative than just the deer in the headlights. It's more indicative of it's basically evidence that this person is trying to hide something from the officer, and the officer not unreasonably took that into account, as I understand it.
So I understand, and I think that is I think that point is distinct from the reaction. But even there, I guess I would say a couple of things. So first of all, I do think that a number of these factors are discussed. We've already discussed the Hawkins decision, and there's a couple of other Fourth Amendment decisions from this court last year. In addition to Hawkins, that the Golden decision and the May decision. So Hawkins, Golden, and May. I think the trio of decisions address a number of factors in terms of sort of evasiveness, reaching for particular, furtive gestures at a particular area of the body or particular area of the clothing, declining to speak to the police, high crime area or evidence of crime. And in those cases, the court generally did not, concluded that none of those, or most of those, did not suffice to justify the seizure. And again, those cases are all Terry stops, reasonable articulable suspicion, which is a lower standard. But again, I would say, again, that while vials are, vials may not be as common as water bottles, but they're not uncommon, because, I mentioned the essential oils example, but I mentioned a number of other examples too. Vials are where insulin is stored in vials, childhood, child ibuprofen, ibuprofen for babies stored in vials. It's a useful way of holding things. It also, in many of those instances, maybe not the essential oils, but certainly the insulin or some of the other things, if it's medicine at all. That
Mr. Lepper, these examples you're referring to are not in the record. And I'm wondering if it's fair for us to factor them into our decision.
I think it is, because I think these are less adjudicative facts and more just kind of
Judicial notice?
Well, I don't even know that it's judicial notice. I think it's information that courts regularly consider when analyzing what is a reasonable expectation of privacy. Even Ball talked about, Ball and some of the other cases talked about, pardon me, in Dickerson, for instance, which was I think the first, this court's first
Wait a
plaintiff.
minute. Are we talking about a reasonable expectation of privacy here? Or are we talking about probable cause?
Sorry, so I guess reasonable expectation of privacy, I apologize. The reasonableness of a search is what I meant to say. I apologize. And so ultimately the question is the search reasonable? And I think the court can, in the same way that a court will look at sort of, the level of privacy associated with a particular, a house or the street or a car, or what an object might feel like or might not. I think these are things. So Dickerson, this court's, I think,
can I stop you for a second?
Yes.
I mean, I take it your larger point, which I don't necessarily disagree with, is that courts can take into account things that every citizen knows, basically.
Yes.
Things that are easily confirmable too. But the issue here is not the reasonableness of the search. The issue here is whether the totality of facts and circumstances amounted to probable cause. The search was a consent search. And it's not that the officer perceived and it was still a consent search, as I understand it, when the officer perceived through the plain field doctrine, something that he took to be a vial that could have been contraband, that he drew the conclusion it was contraband. So we're not really talking about the reasonableness of the search. We're talking about whether the totality of facts at that point, given all the officer knew, amounted to probable cause to believe that this was contraband in Mr. Ford's pocket. And, was a second issue is, do we take into account Mr. Ford's grasping attempt to prevent the officer from looking in the pocket or not? Okay, that's an issue, but we're not talking about reasonableness of the search here.
Well, I think we are, and I don't want to belabor the kind of, I don't want to belabor the point, because I think, but I think we are, in the sense that after Mr. Ford revoked consent, the officer pulled an object out of his pocket, right? And that is, whether you want to call that a search or a seizure, I suppose. I think our argument doesn't depend on that, but I think the broader point is,
if there was probable cause, he had the right to seize it.
If there was probable cause, and I guess my broader point is, when you have when the touchstone of the Fourth Amendment is reasonableness, then the court may consider other circumstances. In Dickerson, the court noted, for instance, that the contour or mass of certain objects may make their identity as contraband immediately apparent, but others are likely to be more ambiguous, and gave examples of cigarettes, candy, other small packages. And in Ball itself, the court was talking about how a pill bottle has many other lawful uses. And I think that's the type of analysis that courts regularly do and have to do to determine whether what was felt is sufficiently indicative of illegal activity. And that is ultimately, I think, the point here, that even if you take into account that Mr. Ford was concerned about something in his pocket, which again itself, and I think this is I think the point I haven't discussed yet, but the discussion about he was sort of turning away because he didn't want the officer going into the pocket or whatnot, or aware of the pocket, is again vials, and you have to look at, the Fourth Amendment requires the court to look at this from the perspective of an innocent person. A vial, if you have a vial of medicine in your pocket or something like that, that itself is something you don't necessarily want the government, looking at or finding out about, because it's kind of very private information. And so there are, entirely innocent explanations for why a person would be startled upon seeing multiple officers in his apartment building coming out of the steps as he's about to enter in. Number one, but number two, that all we know is he had something sensitive in his pocket, but that could be a lot of things. Could be medicine for a condition that is sensitive or embarrassing, or something you certainly don't want disclosed or shared with the government. And so looking at this from the perspective of an innocent person, the standard is ultimately probable cause, but the component pieces have to sort of have enough heft to get there. And especially when the initial feel is, when a vial is not only consistent with a number of lawful uses and surrounded by layers of rubber and plastic and being felt through the fabric of someone's pants. So that even that what was
What
felt,
do you think the significance of being surrounded by a number of layers and plastic is? I had thought that you were implying that we should doubt the officer's claim to have felt the vial. But that's problematic for you to ask us to do that, because we have a finding of fact to the contrary.
I'm not asking
Well, I'm
you.
not sure I understand what you think the significance. I mean, if anything, it strikes me as making it. I don't know. I don't know if I really want to say this, but maybe it makes it even more suspicious that it was surrounded by layers of plastic and a rubber glove and whatever. What do you think the significance of that is? You mentioned it.
Well, so a couple of things. So the first thing is, we're not asking you to challenge the factual findings. So we are not disputing the officer's subjective understanding that he believed that what he was feeling through the outside of Mr. Ford's pants was a glass vial. But the reason that the touchstone
Do you concede that he reasonably believed that?
Well, this is exactly. And so I think because the standard is ultimately objective, and I think the reason why there's an objective backdrop to the subjective understanding is that officers get hunches, right? And this officer testified that he thought PCP before he even touched Mr. Ford. He was just like, I saw a bulge in his pocket. He basically reached the conclusion before even approaching him that Mr. Ford was a PCP dealer. And if you come in with that sort of presupposition, you're going to be more likely to interpret what you feel consistent with that. And that is why, so it's not a reason to discredit the factual finding, but it is a reason to, it's a reason why the standard is ultimately objective and not subjective. And so I think that's I think the point we're making there. As to the layers and whatnot, I think had the officer testified that, yes, I felt the glove and I felt the bag and the baggies, and it's my experience that, that's how people store their illegal powdered substances, and there are no innocent explanations for that. That would be one thing. But I think, again, because it's through multiple layers of fabric, you don't get that, and he didn't get that detailed an understanding. You just it feels like packaging material in the same way that when you open a package or something and you reach into it, and if it's got bubble wrap around it or packing paper around it or whatever, the specificity of what you're feeling is diminished. And that's important here because there was a lot of discussion at suppression hearing about, well, could it have been 5-hour energy? Was it a plastic bottle? Was it a plastic bottle? Was it a glass vial? So it's depending, even the sort of quote consistent with determination was itself depended on a number of specific determinations about what exactly was being felt, and it just seems objectively not reasonable to ascribe that level of nuance when there's that many levels of fabric, textile, synthetic substances, and the like in between it. But ultimately, I would say if you're looking, ultimately the inquiry is holistic, and holistically, what happened here when you have consent, a revocation of consent upon an escalating, more intrusive search, which is consistent with innocent behavior, the feeling of an object, which is in and of itself not, it may be consistent with illegal use, but it's also consistent with legal use, and sort of very vague evidence about, PCP use without sort of linking it to, Mr. Ford or any distribution. The holistic fact pattern does not rise to the level of, the outer edge, which was identified in Ball and several of the cases identified in Ball. And, I'll sort of leave it with this, the police department, identifies a number of things that they say are consistent with PCP use. They talk about, on their website, they talk about glass vials, but they also talk about aluminum foil and eyedroppers and parsley. And I think, all of those things, I mean, you could feel that thing and say, well, I know it's consistent with PCP use, but I think those things, several of those, I think would raise many eyebrows. And I think there's a similar reason to be concerned in this case, given the sort of generality of what the officer felt, and given the, I think at best ambiguous attending circumstances accompanying the non-consented portion of the search.
Counsel, thank you both very much. The case is now submitted, and you may log off.
Thank you.
This honorable court is now adjourned.